Good morning, everyone, and thank you so much, Shruti, for having me on this session. I'll just start by sharing my screen, although it appears that I am unable to do so.
Give me a minute, Rose. Let me have a look.
As you're doing that, Shruti, I'm happy to continue to speak to the presentation, just in the interest of time.
You should be able to share shortly. Actually, I think now you should be able to share.
All right, let me try again. Wonderful, I can.
Great.
Thank you. Thank you so much for that. Just expand that. Wonderful. So as has been mentioned, my name is Rose Macero from the Office of the Data Protection Commissioner. I serve as the Deputy Data Commissioner and head the Compliance Directorate. Just a little bit about what data protection is and where it emanates from. Everyone in Kenya has a constitutional right to privacy. And so the Data Protection Act effectively picks its application from Article 31 of the Constitution that provides every person with the right not to have information about their family or private affairs unnecessarily required or revealed, and also not to have any privacy of their communications infringed. We also have Article 35(2), which is a right that ensures that every person has a right to correct or delete any information about them which is untrue or misleading and affects them. In terms of the Data Protection Act, the Data Protection Act is relatively new. Well, it's been around for a few years, but still, in the context of data protection, it is relatively new. It was enacted on the 25th of November 2019, and the office was actually established or operationalized a year later on the 16th of November 2020, and so data protection has just been around in Kenya for about 3 years now, which is a lot shorter than a lot of other countries have had it. You know, the EU, for example, has had data protection regulations for over 40 years. Other parts of the globe have had it for, 30 years, 33 years, and things like this. So the culture of data protection is relatively new. One of the things that had to be done after the enactment of the Act was to actually find a framework to enable people who are being regulated, institutions that were being regulated, to comply, and also to find easier ways for them to actually understand what the law requires of them. This required the development of a few regulations. Initially, it was only thought that there would be one regulation, but it turned out to be 3. The 3 that are relevant to you as an industry are the data protection general regulations, the Data Protection Complaints Handling and Enforcement Procedure Regulations, the Data Protection Registration of Data Controllers and Data Processors Regulations. We also have a fourth one, which tends to be forgotten often, called the Data Protection Civil Registration Regulations. This applies to you as an individual because it governs how the government collects your information for the purposes of registering you as a person. So if you're getting an ID, a passport, if you're registering the birth of your child, or in the unfortunate circumstance that you have to register a death of a loved one or anyone, the civil registration regulations will come into play. Now, I'll just speak about, I won't touch at this moment on the general regulations and registration regulations because I'll speak about them in more detail. But I'll talk a bit about the complaints handling and enforcement procedure regulations. It was mentioned that, we've seen a lot of things in the media about the fines that we've issued as an office. The reason for that is it emanates from the complaints handling and enforcement procedure. The Office of the Data Protection Commissioner has the powers to investigate any complaints or any breaches or violations of personal data. And how it manages that is it can either receive a complaint for an individual, a data subject that is affected by a violation of their data, or it can, based on media reportings or just an issue of public interest, investigate a complaint. And if it finds that an institution has breached or violated the Data Protection Act, there are certain procedures that are followed. Usually there is an enforcement notice that is issued, and I'll speak about that a bit later, which pretty much provides an opportunity for institutions to actually get their act together and put in certain provisions, put in safeguards and things like this, policies to ensure that they're complying with the Data Protection Act. If they don't do so within a specific time, then they'll usually be hit with a penalty. So the time for compliance with an enforcement notice is 30 days. If after that 30 days you have done nothing and you've made no steps and you've not communicated with the office, then the office will usually issue you with a fine. The fine is 5 million or 1% of your turnover, whichever is lower. So there's always a cap of 5 million Kenya shillings. However, there's a lot more at play than just getting your institution fined. And I'll speak about that a bit later on. There are a number of players in the data protection space, so I'll speak about them just before I dive into my presentation. The first one is a data subject. That's effectively you and I, a natural person, people who have 5 senses or entities or individuals with the 5 senses. So that is a data subject. Then there is a data controller. A data controller can be a natural person, a legal person, a government agency, a non-governmental agency, can be a combination of institutions that effectively determine why information is collected and the means for collection of that information. And then a data processor is someone who processes information on behalf or handles information on behalf of the data controller. They have no other obligation, or they're bound by legal obligation or contractual obligation to collect information or to process information or to handle information on behalf of the data controller. Now, this doesn't include employees because employees effectively act on behalf of the institution itself. And so if they're employees of the data controller, they would be deemed to be the data controller. And if they're employees of the data processor, then they will be deemed to be the data processor. Of course, there are exceptions to this. For example, if you have an employee that is rogue and is doing things outside of their instructions, and they have the capability of being dealt with as a data controller in their own right. One of the things that I love to say about, some of the obligations that we have specifically as data controllers and data processors, and many of you will fall under the category of both or one. So for example, if you're advisors, you probably will be data processors. However, you all probably have HR functions as well. So by virtue of the HR function, you would be data controllers. So the Act outlines a number of obligations. However, they can be broadly categorized or fit into the following principles. The first one is that every processing activity. Now, when we talk about processing, I'm talking about handling of data in any way, from collection all the way to deletion, sharing, disseminating, whatever it is, must comply with the data protection principles. Shruti tells me that I think they'll be coming in later on to talk about the data protection principles, but they are globally accepted principles. I won't go into too many details about what they actually mean. So, for example, you need to ensure that you have a lawful basis for collection of the information, that you have protected that information and safeguarded the confidentiality and integrity of the information. You put in place procedures to enable transparency so that the people that you're dealing with know exactly what you're using information for and the like. You need to ensure the data subject's rights are paramount. One of the things that has shifted greatly since the enactment of the Data Protection Act is that you now have a responsibility and a duty to ensure that you are taking into account the individuals who you serve. So, for example, members of pension schemes are data subjects. They need some level of protection. They have a number of rights, which I'll speak to a bit later on. And so you need to be able to ensure that they're able to exercise their rights, but you're also taking into account in your procedures and in your practices their rights. So, for example, I have the right to access my information, and this is an absolute right. If I decide that I want to come to you, or perhaps maybe I'm a member of a pension scheme and you're an advisor, and I say, okay, fine, I want to collect my information. I want to have access to all the information that you have about me. You would need to be able to ensure that I can access that information within the time frame that is stipulated in the Act. There's a 7-day time frame, and so you need to be able to put in place, or you need to be putting these things in place to ensure that you're able to serve your members in case they have any data subject rights requests. Another request, for example, that would be relevant to this industry is if I want my information ported. Perhaps I'm not happy with a specific pension scheme and I want to move to another. I don't want to start from scratch to give them all the information that I've received. There is a principle, or there is a right where I am allowed to request for my information to be ported. It's a right to portability, to be ported to another institution. If that is the case, you need to make my information available in machine readable format to the institution that I wish to port it to, and you have to do it within 30 days and only charge me what is reasonable. So exactly what you have spent is what you will charge me. So one of the things that I've noted is some industries in terms of access or porting of information tend to charge quite an amount to individuals. You're no longer able to do this. This means that you have to find creative ways. For example, you could send information by email, which cuts down costs. You can, and this is for access requests specifically, you can have people come into your office for access requests to actually look at their data on your platform, so you don't have to necessarily print it. Obviously, you have to do so in a safe way. And the third thing is the implementation of appropriate safeguards to protect personal data is key. The aspect of data protection needs to be looked at not only as serving the digital aspects or the digital functions of your office, but it needs to also target the manual aspects of your office. And I'll speak about that just a bit later on. So there are a number of things that came into effect after the Act was enacted, and the regulations, specifically the general regulations, came into effect last year in February. One of these, which I've spoken about, is data subjects rights requests. I won't go into detail about that. I know that pension schemes are restricted with respect to how they can use data, and so I won't talk too much about commercial use of personal data, other than to say that if there is any aspect of direct marketing that is employed by your institutions, or you wish to utilize, you need to ensure that you have consent. And obviously you can't use sensitive personal data, say your health status, your financial information, or anything that you've obtained that is deemed to be sensitive for the purposes of direct marketing. There is a requirement that all institutions have a retention schedule or retention policy. This is something that effectively outlines the information that you have and the duration of which you need to keep that information. Upon the lapsing of that duration, then you would have to delete the information. A retention schedule if for the purposes of the Data Protection Act, we don't actually specify the time period for which you need to keep information. This is governed by the acts, actually the statutes that govern you, but also a justification that you need to do as advisors with respect to the members' information that you hold, or even your staff or whatever it is. So you need to take this into account. One of the things as well that you need to take into account is the data protection policy or notice. There's this works in two ways. There is the internal policies that you should have when it comes to data protection, how you're dealing with incident responses, when it comes to data breaches, how you're dealing with data subject requests, the sorts of information that you collect, the safeguards that you put into place, who's responsible for what. Those things are necessary, but there is also a requirement to have an outward facing or an external facing documents that actually speaks to your members or your clients about how you're using their information, who you're transferring to, where you're storing it. Are you storing it internally in Kenya, or are you storing it in the cloud? What sorts of security measures can they anticipate that will be adopted by the cloud service provider that you're using? There's also another aspect of data sharing. There's a requirement for you to enter into contractual arrangements when you're sharing any data, especially if there's no legal obligation as such. And when I say legal obligation, it means there's a statutory requirement. So for example, there are sometimes that you need to give information to, I don't know, the revenue authority, or perhaps you need to share information with the RBA and things like this. In those instances where it is founded on the law, there's no requirement to have a data sharing agreement. But if you are sharing on the basis of performance of a contract or whatever it is, say, for example, you as an advisor want to get information from your from the pension schemes that you serve, they need to share information with you. That aspect would require a data agreement, specifically if you do not have that obligation where you are providing a service to them as a data processor. However, if you are providing a service as a data processor, you have to enter into a contract where it stipulates that you're a data processor, provides for a number of things, including audit functions, where you can make arrangements as to who's going to audit the security measures that have been put into place, the duration of time, specification of the sorts of information that is being collected or processed, clear instructions as to what is acceptable and what isn't. We'll skip through data protection by default and design. I'll speak about that later. And the rest as well: cross-border data transfer, data protection impact assessment, and registration. So data protection impact assessment, and this is a requirement for many of you. There is, well, not a requirement. It's really, from a regulator perspective, it is an advisory. There is a requirement under the law that if you are entering into a new processing activity, so for example, you are changing how you're processing member data, or perhaps there's new technology that you're including, and perhaps you're advising the pension scheme, whatever it is, you would have to do a data protection impact assessment, and you would have to do it within 60 days prior to your commencement of the processing activity. However, I am a very firm believer that a data protection impact assessment is crucial for any institution to do. You don't necessarily have to send it to us as an office, especially if it's not being done within the confines of the requirements of the Act, which is a new processing activity. But it is crucial that you do a data protection impact assessment, because you are not going to understand the risks that attach to the processing activities that you're doing. You're not going to attach how you're not going to understand how you will enable members to actually do what they need to do. You won't be able to understand the sorts of investments that you need to put into place for data protection compliance. You won't understand the sorts of tools that are necessary, the policies that you need to come up with, and things like this. So it is a very effective tool to have as an early warning system, but it is also a really important tool for decision makers, so that you can influence the sorts of investments that will be put into place to then protect the information that you have in your custody. Another thing that we talk about, which is a requirement under the law, it is a mandatory requirement that you think about, the data protection by design or default. What this means is that you're taking into account data protection at the initial stages, at the ideation stages, formulation of new activities that you're entering into, and also that you have data protection embedded in your system, so you don't have to really think about what sorts of things that you're doing in the data protection space. You already know that you've accounted for incidents reporting. You already know that there's automatic data protection safeguards. There's technologies that you're using. If, for example, you have very manual processes, you know that you're keeping information in safes and no one has access to these things. So really just ensuring that data protection is integrated into the core of your functions as a business. There are a number of principles when it comes to data protection by default in design. There are 7 similar to the principles of data protection. This means that data protection by default in design needs to be proactive and not reactive. So in the sense that you need to ensure that if, for example, you are starting a new process or you're just carrying on with your issues, you would do a data protection impact assessment. It will tell you the risks. You would also determine how to mitigate. You would put and implement whatever safeguards you need to put into place for data protection sake. That way, if an incident happens, you are in a better position. So you've seen issues about ransomware. There are viruses for that are malware issues that are also coming in play, cybersecurity threats that are coming into play as well in all industries. So if you have safeguards from these things, not to say that you'll be completely risk-free, but at least you'll be less affected. So for example, if you have encryption in the information that you use, it is unlikely that a ransomware attack would affect you because, well, they have the information, but they're not keeping you at ransom. The information is encrypted. You also need to ensure that you have backups. So for example, again, if they're holding that information, you can always call on your backup to say that's fine. You know, the information is encrypted anyway, and it's the best encryption. So you're never going to be able to de-encrypt that information. We've also done a situation where we're data masking or we're putting information in different data servers. We have a backup. And so whatever it is that you do, it's not going to stop our business. We're going to be able to move on. Privacy as a default setting, as an example, is having practices in place. So for example, the simplest of things is training your staff to ensure that they think about privacy even as they're doing their day-to-day jobs. They understand that if they do this, it will be a breach of the Privacy Act, and if they do this, then they will be compliant with the Data Privacy Act. So that's in the simplest form and aspect of data protection or privacy as a default setting. Embedding privacy into design. So as you're designing your new activities, as you're designing your programs, if you're entering into a phase where you're automating or digitizing your processes, ensuring that you've embedded privacy through use of privacy enhancing technologies, not only just thinking about privacy as an instance of having a firewall and that's it, having full functionality. So having a positive sum, not a zero-sum game. A lot of people tend to assume that if you do take into account data protection, then you're not, or you have to forego issues of what would we call it? Issues of your bottom line or whatever it is. Like, you look at, I don't want to invest fully into data protection because then my budget, or I know that pension schemes don't have profit, but you'll be eating into some of these things. But it is important for you to look at it as a positive sum. Data protection is relevant for everyone. There are certain economic benefits that come around for data protection, such as consumer trust. You get an edge, a competitive edge against your competitors and things like this. And so you need to look at it as what will data protection benefit, or what will be the benefit of data protection for me, and then adopt that as a full functionality sort of aspect. Ensure end-to-end security, so full life cycle, so determine what your processes look like and ensure that from the beginning to the end of a data life cycle that you've ensured the security of it. Visibility and transparency, this just means that you're talking to your clients as well and just advising them and your members, advising them of what you're doing with respect to data protection and how you're valuing, I guess, their privacy. And this could be done basically by just having a policy or a statement to let them know this are the safeguards that you put into place, and just have conversations with them about how they would feel more secure about their privacy. And respect for users as well. So ensure that you're keeping the data subject or the user or the member or the client in mind at every stage of your data protection journey. There are a number of things to consider as well about cross-border data transfer, specifically for your sector. One of the things that we get asked a lot, and something that I guess demystifying for your sake, is we are asked, can I transfer information out of the country? Yes, you can. You can transfer information out of the country. However, there are conditions for doing so. The first one is that there needs to be appropriate data protection safeguards. This can come in very many ways. It could be that you demonstrate or you're capable of demonstrating that someone has put technical and organizational safeguards. This means that they've put technology aspects. There is, the things that I've talked about, encryption, all of these things, so that it is the confidentiality and integrity of the information is protected, but also there is access controls, there's policies, there's things like this to ensure that not everyone has access to that information. If you can show us that as an office, or you can demonstrate that in case you're asked about this process, then you can transfer information out of the country. Another adequate safeguard is also having contractual obligations with the people who you're transferring information to. So for example, if you're holding your information on the cloud, contractual obligations are really important. Another thing is, if you're operating in very many jurisdictions, you can have binding corporate rules, which is also effectively a contractual obligation that binds everyone that operates within your group, including the employees, to adhere to specific data protection provisions, and specifically the Data Protection Act. Then there is an adequacy decision or deeming adequacy decision. You can always approach us with this if you want to understand what the adequacy decisions are. But this effectively just is a decision made by the data commissioner to say that a particular jurisdiction has adequate or essentially equivalent laws. So for example, if you're transferring information to the EU or an EU country, we will usually say that there is, it has essential equivalence or is very similar to the laws of Kenya, and they have they have probably more protections, and so it's fine for you to transfer information to that country. Deemed adequacy provisions, there's specific countries in Africa that are deemed to have adequate laws. These are the ones that have signed the Malabo Convention. This is the AU Convention on the cybersecurity and personal data protection. This is, countries like Rwanda, Ghana, Senegal. They're about 13 countries at the moment. And so if you transfer to any of those countries that has ratified the Malabo Convention, you would be fine. You can also transfer as a necessity. Say, for example, you've got a contractual obligation that you need to fulfill. You have a legal claim that you need to defend or mount. You have a data subject whose rights you're trying to protect. In those instances, you can also transfer information out of the country. Consent as well, if all the three don't actually come into play, you can transfer information on the basis of getting consent. But when you get a data subject's consent, for transfer, you have to ensure that you're letting them know of the risks, and this is one of those things that you do. But specifically, you need to note that if you're transferring sensitive personal data, this is financial information about a person's beneficiaries and things like this, you need to seek the consent of this individuals to transfer that information. Data breach, which is an interesting one and has been mentioned, so I think it's only relevant for me to bring it up. A data breach effectively is if someone has access, unauthorized access, or there's a destruction, loss, alteration, the data has been transmitted or stored or any way processed in a way that is unlawful, unauthorized, whether it's accidental or not, you will have a data breach situation. In this case, if you're a data processor, which many of you would be, you need to notify the data controller within 48 hours of becoming aware of the breach. You need to tell them what has happened, what you're doing to mitigate the measures. And if you're just realizing what has happened and you're still investigating, you can also tell them, this is what has happened, this is what we suspect, we're still investigating. The data controller then has 72 hours upon becoming aware. So this is, if you report to them, say 12 hours into the breach, then on the 12th hour that you've reported to them, their 72 hours start to come into play. So they will then need to tell us within 72 hours of what has happened, give us information, and it could just be preliminary information as you're investigating the issue, and we'll work with you effectively to ensure that you're dealing with the breach adequately. In this instance, we will not shame you. Sometimes people are scared about that. It is not something that we announce that you have issued a data breach. In fact, we keep this data breach notifications extremely confidential, in that only my team in the office and the data commissioner are aware of the institutions that have actually reported. And so you become a statistic effectively for the rest of the office of the data protection commissioner. So if we have to report, you become a statistic. There is no name that is attached to you. There are no details of the breach or how you've dealt with it. And so we will keep that confidential because we understand the sensitivities of data breaches, and sometimes it is not the fault of the institutions that have been affected, and so we deal with it in that way. However, if there is an incident of a data breach and we receive a complaint, we will transfer our findings to the complaints directorate, who will then look at it and make a determination on what next should happen, whether you have addressed the issue satisfactorily, or they can make a decision to investigate the issue, just to understand what you have actually done specifically for the data subject who has complained. We also have a requirement for registration. Every entity effectively that collects personal data is required to register. And there are some exemptions, which I'll talk about in a minute, but the application process is all digital. And so what happens is you provide, or you make an application, you pay the relevant fees. We then verify the application. It says the data commissioner because she's the head of the institution. And then we will issue you with a registration certificate, and then there will be a renewal. A number of you have made an application, you've paid the fee, the verification process is meant to be 14 days, but the information that you have given was not sufficient. We do not deem your application to be complete and for the 14-day timeframe to run unless you have given complete information. So for example, you have to look at the technical measures, and I'll go into this. So this is what the registration platform looks like. Effectively, it's digital. So we go to verification, you provide your basic details of an institution that is registering, and then you will provide the personal data that you are collecting. So for example, you'd give the category of people, you'd say employee, and only give one category, employee, then you provide the description of the information that you collect. Do not give any personal information. So what you say is you collect a name, you collect an address, you collect an ID number, you collect a KRA PIN, you collect certain information, and then you state the purpose. For you, for example, it might be that you're collecting information for the purposes of advising a client. Do that. Then there is sensitive personal data. This is racial, ethnic information, property details, marital status or information about children's details, religious or philosophical information. You will advise if you collect this and provide a description for it. You will then tell us if you transfer that information to another jurisdiction. And you will give us information about the risks that attach to the processing that you do, and also provide safeguards. Putting firewalls is fine, but you need to give a bit more information, and it needs to be both technical and organizational. So you can say that for organizational measures, we train individuals that process information on our behalf. We have put into place contracts and NDAs to ensure that the confidentiality of information is protected. We have policies that we put into place and things like this. For technical measures, you can put firewalls, you can put antivirus things, you can put you've put, you use encryption solutions, you have access controls and the like. And then employees, you need to specify how many you are. A number of pension schemes do not have employees, and we appreciate that. So there is a tab that allows you to select 0 to 9. And then you would then put in your turnover, which is the income that you have, or that is the income that you're allowed to spend, effectively what revenues the pension scheme might have specifically. So for example, it could be not specifically the members' earnings, just the income or the revenue that has been generated for the members' contribution, for example. And then you would then go into paying and you'd move on from there. You would likely, as a pension scheme, would likely to fall under the micro and small data controllers. The reason for this is that there is an and provision. So if you have 0 to 50 employees and an annual turnover of 5 million, you would be considered to be a micro. However, if you have 0 to 50 employees, but you have a revenue or turnover of 50 million, because you do not fit into the and category, you would still be deemed to be a micro and small enterprise or data controller or processor. So there are certain categories that come into play. A lot of institutions that we've seen, a lot of pension schemes have started putting in that they're non-governmental organizations or public benefit organizations. This is not correct. You need to put that you are either a micro, medium, or large. Do not select charities or religious religious entities or public entity unless you are, in fact, one of those. There's a mandatory registration exemptions, which unfortunately, because you fit into the private, the financial service provision category, you do not fit into. However, there are some organizations that do not have to register. These are ones that have a turnover of less than 5 million and less than 10 employees. However, if you fall into any of the categories, both in your personal capacity or in your capacity as an advisor, provision of advisory services, then you'd have to register on that basis. As I've mentioned, there are some consequences of non-compliance, issuance of enforcement notices. We're not here to penalize, we're here to work with you. And so an enforcement notice would effectively tell you what you need to do. And then after that, if you do not do it within 30 days, or you do not tell us that you're putting in steps to do it, we will issue you with a penalty notice. I'm sorry, yeah, and a penalty notice, as I've said, 5 million or 1%, whichever is lower. There are some benefits, and I won't go into this, but you meet the compliance requirements, which is the least of them, but you protect breaches which hurt the business. This could be financial hurt, not just from the fines that we give, but also in terms of loss of trust. Sometimes, like for ransomware situations, we found, even though there is an advisory not to pay, we found that people have made payments for this. So that could also hurt the business in that way. Recovery also takes a lot of money. You're protecting the data subjects, you're maintaining and improving your brand value, you maintain member and customer trust, you're able to support your members' wishes, you have a competitive advantage. You've also increased physical safety. I know this sounds like an odd thing to say, but in a number of cases, we've seen data breaches could even result to death because people now know where a certain person lives, or where they work, or their children, and things like this. And so you just need to be careful about that. There's loyalty as well, and there's innovation that can be spurred by compliance, because you're able to then utilize the information that you have more effectively. And with that, I think I've taken a bit longer than I should, and my sincere apologies. I have finished on that front, so I will stop sharing and give it back to Shruti.
Thanks very much, Rose. Wow, you really packed in a lot, which and all quite interesting and relevant to our audience today. I think, just take this opportunity to say that the ODPC has made some really, really big strides in such a short time. So kudos. Some of the things that I picked up from your presentation was, being proactive rather than reactive, embedding data privacy into design and culture. And I think one of the things that you talked about at the end, which I'm also a big advocate of is looking at it as a positive, looking at data privacy as not just a compliance thing, but also the other benefits that it could have for an organization. So thank you very much. We will be taking questions at the end. Next up, we have Fred Getkonde from the RBA. Fred is an advocate of the High Court of Kenya, a certified mediator, and a member of the Chartered Institute of Arbitrators in Kenya. He's the current legal officer at the RBA and a trustee trainer at the College of Insurance. I asked Fred if when he enters a building, does he give the correct information to the security guard? And he said he does. Fred is most protective about information about his family. And he also seems to be getting a lot of these messages that he doesn't seem to remember subscribing to, especially during campaigns. So I'd like to welcome Fred now. Fred will be talking about the implications of the Data Protection Act on retirement benefit schemes. Welcome, Fred. You can now share your screen.
Thank you very much, Ruti, for that introduction. And also I would like to thank Rose for giving a very good presentation, which really covered quite a number of things which may also want to discuss. I don't know, it is telling me, it's not allowing me to share. Maybe, I don't know, maybe you can allow me to share my screen, please, Shruti.
Okay, give me a minute. Let me arrange that.
Yeah, just as you're assisting me, I would like to say that the Data Protection Act is a law which came in handy to govern an area which was lawless. We didn't have a law which was governing that regime of data. And it has really become a big thing, especially in the employment and the pension sector. In most cases, people fill out job applications. When you fill job applications, you give out your personal data. You could be filling information like nomination forms to the scheme. So in such a case, of course, you are also giving information, payroll information, medical information, especially when you have an external person who provides medical, like the insurance company. And sometimes you also give residential data. So those are quite a number of areas whereby you could be providing information to pension schemes or employers, and really that data protection needs to come in. I'm trying to share, but I will go straight to.
So Fred, we can see this. I can see the presentation. It's on the screen.
Oh, okay. Just
maybe to change it to the presentation mode.
Yeah, that's what I'm trying to do.
Maybe where it says view or slideshow, maybe at the top.
Yeah, I'm getting there.
Perfect.
By now?
Yes.
Yeah, so I would like to associate myself with the introduction given by Rose in terms of the history of this act, the reasons behind this act, that is some aspects of the Constitution. There's the right to privacy, and that is Article 31 of the Constitution, and of course, Article 35(2), that is the right to correction or deletion of some data which is not true about an individual. So I will go straight on what are some of the compliance requirements when it comes to pension schemes. And of course, when I'm saying pension schemes, sometimes it could also apply to employers, because employers collect some of this data from employees. So what are some of the implications of this act to us as schemes and probably as employers? So we'll be required, of course, to register with the Office of the Data Protection Commissioner, and of course, the registration has been going on from last year, around July. So I recommend that, of course, you are registered as a data controller or as a data processor. But it's my recommendation that we try to register as both, especially, I can give an example. For example, a scheme administrator, in terms of processing data of the scheme, in terms of that data you are getting from pension schemes, you are a data processor because you are not the person to collecting. You're doing it on behalf of trustees. But also what you will find is that as an administrator, you're also an employer in one way. So you have an HR office, you employ your people, and you collect data from them. So in that case, you're also a data controller. So to avoid maybe any risk or maybe Rose and team coming for you, the best thing is to register for both as a data controller and a data processor for that case. There is also a requirement that schemes and maybe administrators and fund managers and of course custodians. There's also the requirement of appointing a data protection officers. Of course, it's not a mandatory requirement under the Data Protection Act, but it's something which is highly recommended because this is the person who really guides the service providers, the employers, the schemes, and in fact, it will act as a link between the Office of the Data Protection Commission and of course the schemes, and is the person who is trying to ensure that all these policies which Rose talked about are implemented, and of course is the one who will guide the whole regime of this data protection. So it is highly recommended, and of course, once you appoint that person, of course, he doesn't need to be the employee of the service provider or that organization. You can even share a data protection officer. In that case, it will be, in terms of costs, it will be a bit easier. And of course, there's a requirement now under the Act that once you have that data protection officer, you need to publish his details in your website. And of course, you need to communicate with the Office of ODPC so that they know this is the person who is representing you as the data officer. As schemes also or employers, there are some of the policies which, of course, we don't have an option. We need to come up with them. Of course, the data protection policy, and some of them, Rose has talked about it. And there is also data privacy and security policy. There is employee privacy policy. There is a data retention policy. So in my opinion, these are some of the policies which we need to come up with, and they will be one step in helping us trying to comply with this law. Maybe Rose will guide us later whether we can have one of them, like now data protection policy, which will entail some of these things like data retention or data breach, or we need a separate policy for each separate event like data breach policy or data retention policy. But then to be on safe side, it's good that you start planning to have some of these policies in place to ensure that you are complying with these requirements. Another thing which is key is that it is now high time for schemes or employers to try and regulate some of the information they are collecting from people. There's some of these personal data or sometimes sensitive personal data, which you don't need there is no need to collect it from the data subjects or the employees or the members of the scheme. So as Rose will tell you, the less the information you collect, the less the lower the risk. So if you don't need much information, there is no need to collect it. There's some data which, for example, matters to do with someone's tribe, someone's blood group. There's some things really you don't need, but you find yourself collecting. So it is high time. I know because this area was not regulated, that is before 2019, we were collecting so much data from people. Some of it was not useful, but because we had that obligation, we used to do it. But now that this act has come in place and has put in all those rights for these data subjects, it is good that we assess the kind of information. We can do a reassessment as an employer, as a scheme trustees. What are some of these data we don't need from these people, so that you can stop collecting unnecessary data? Yeah, so because if you collect so much data you don't need, some of them can run into high risks, and someone can sue you if it gets out there. The other thing is that schemes or employers also need to put in place some of the response mechanism, especially to complaints of personal data breach. So going forward, of course, people will be complaining this data, they are the rights of the data subjects under the Data Protection Act. So people will be, bringing complaints. As I have a right under the Data Protection Act, what have you done to, there's some information which I found somewhere, at least now people have a basis to launch some complaints. So it's good that schemes now ensure that they have quite an elaborate way of complaining. I think this can also be embedded in some of those policies that schemes are expected to come up with. And of course, another key thing is training. Schemes and employers really need to educate their staff. And of course, that's why I insisted that it's good when you have a data protection officer within either the institution or a person who regularly comes to train these staff is key, so that the staff can understand this act. It's an act which came 2019. So not many people are aware of it. So awareness is the first step in implementing any law. And I think it is good that schemes and service providers ensure that their staff are adequately trained, they know what is going on. And some of the things is to ensure that their employees and also members understand some of the rights. For example, the right to be informed of the use of their personal data. When you are collecting a personal data from someone, you need to be informed. We are collecting this information because of ABCD. So sometimes people never used to ask such questions because maybe there was no obligation or they did not have that right to ask. But now that the law has come in place, these people could be asking such questions. Why are you taking this data? Why are you asking the name of my wife? I mean, why do you want to know the name of my child? So it's good to have a response mechanism, because that is, they have now a right to be informed on any information which you are extracting from them. They also need to be told that they have a right to access their personal data in custody, so they can come in anytime. There's an interesting scenario whereby a question was posed to an HR function in an institution. Someone asked, can I access my file? If I come and say I want to peruse my personal file, can I access it so that I see what is going on? So under this act, it is your right to access your personal data, wherever it is been kept. And of course, so these are some of the rights which we expect to be explained to people or to the data subject, that is either employees or members of the schemes, during some of these trainings, so that they can understand some of their rights. Of course, the other rights, of course, right to object to the processing of their personal data. They can reject in case they see some of the processing of it. And of course, processing entails either storing, keeping that data, for example, if the data is used for research and other things, it entails processing of it. Of course, the right to correction also, and among other things, and the right to deletion. So these are some of the things, the rights which employees and, of course, members of schemes need to be explained to during those trainings, which we highly recommend that they should happen. There is also obligations to have contracts between the data controllers and the data processors, as Rose correctly pointed out. So as you can see in a pension setup, in most cases, the information is given either to the employer or to the trustees. So, and this information eventually end up with the administrator. Sometimes the administrator could be collecting that information, but is collecting it on behalf of trustees. So in that end, we highly recommend that some of the contract, especially some of the contract trustees sign with the service providers, be it administrators, most cases administrators and even custodians. I doubt whether fund managers, because most cases they deal with investment and they invest in the name of the scheme. So I doubt whether they interact with the record of the data subject, that is the members. So here we highly recommend that they should be, or the contracts or the agreements between the trustees and the service providers, that is the administrators, and also even employer and also the trustees. There should be kind of an engagement or an agreement whereby there is that aspect of confidentiality, whereby you are very sure that I'm giving this data to the administrators who have assured me of confidentiality, and that should be demonstrated through a contract or an agreement. So going forward, we are going to see agreements with service providers capturing such aspects of the Data Protection Act, like confidentiality, ensuring that you have proper safeguards to keep this data. Yeah, because as a data processor, if I've given you my information, I'm the one who collected it as a data controller. If you go and mess me up, I'm the one to be sued. So in that case, I should ensure that before I give you the information, that you have serious safeguards to protect this data. So we are going to see that shift of requiring some of those contracts having some clauses to do with data protection. Of course, schemes will also be required to come up with data breach management strategies. Schemes will be required to come up with strategies to deal with the data breach, because now data breach is an offense, as Rosa has explained. So going forward, we are going to see schemes now or employers coming up with such strategies. Rosa has also talked about the issue of conducting an impact assessment before you process some data. Schemes also need to be aware of this, that before they process some data and going forward, they need to conduct an impact assessment to find out whether that assessment, especially when they are dealing with sensitive information, what are the risks if we process this information? What are some of the risks that is going to happen, especially with the data subjects? For example, if we are processing this information and for children, maybe, so what are some of the risks involved? So here again, with the help of the data protection officers, they will come in handy to help schemes to carry out this process to ensure that after the assessment and they find out that the risks are not that much, they will go ahead and process that information. And also another key thing which schemes are going to adopt going forward is to ensure that their systems going forward, be it ICT systems, they are in compliance with the Act. Because the data commissioner may carry out periodic audits, I know, to look at the processes and systems of either the data controllers or data processors to ensure that they have complied in one aspect or another. So I think there will be a complete overhaul going forward to ensure that some of the scheme processes are in line with the Data Protection Act, so that going forward, they are in compliance. And as Rosa and the team will be doing the assessment, so that they will find out that the assessment are in order. The other thing, as I wind up my discussion, is maybe Rose will clarify, because he has really dealt with this issue from the inception. There's an aspect on Section 10 on the delegation by the data commissioner, whereby it's providing that the data commissioner may delegate any power conferred under this act to a regulator established through an act of parliament. Maybe from where we sit as a regulator, we may want to understand, do they mean that sometimes they might delegate some of the compliance aspects to any regulator, might they require the regulator to, carry out some function which they feel like they want to delegate? So maybe she can also guide us on that. And of course, with that few remarks, because my presentation also entails some of the things which Rose has talked about. So I went specific to compliance requirements by schemes, and I beg to end it there and invite questions. Thank you very much, Ruth.
Thank you very much, Fred. That was very useful, I think, especially and very relevant to our audience, being mainly pension schemes, stakeholders, trustees, administrators, service providers. There's just another brief presentation, and then we're going to go straight into the Q&A session. We've also started receiving Q&As in the Zoom chat box. So if you've got any other questions, you're welcome to put them there. Otherwise, we will be taking questions in about 15-20 minutes. So this final presentation is going to be by myself and Amit. As mentioned before, my name is Shruti. I'm an actuary and I sit within the actuarial division at Zamara. I've been working in pensions for longer than I can remember, but I'm also working in data privacy, spearheading the initiative at Zamara, and also helping organizations, specifically pension schemes, comply with the Act. Amit is a dually qualified lawyer, a certified information privacy professional, One Trust Fellow of Privacy Technology, and has over 25 years experience in the legal industry. Amit is a global DPO, Data Protection Officer trainer with the European Center for Privacy and Cybersecurity. He has vast experience in advising organizations of all sizes on data protection, both locally and internationally. So, I mean, some of what we have in the slides has already been covered, so we'll skim through those slides. But I mean, just to reiterate that data protection would apply to, the Act would apply to a lot of organizations, especially if you are dealing with personal data for work, and about people. So if you've got a certain number of employees or a certain turnover, but as mentioned before, as much as it's part of the Act, it was also good practice to comply with the Act. There are other benefits of doing so. In terms of pension schemes, Rose mentioned that data processing is from literally collecting the data to when you delete the data. That is all considered processing. It doesn't necessarily have to be a complicated actuarial valuation. So when we administer our schemes, when we collect contributions, we're privy to a lot of information. When we pay benefits to the right people at the right time, sometimes as trustees, we are exercising discretion, and that leads us to getting involved and into a lot of sensitive data, very confidential information. And on a regular basis, we're making investment decisions about the scheme. So we have information on the age profile of the scheme as well. So this is all considered processing. I'll skim through this because this has already been covered. We've talked about the principles, both Rose and Fred, and I think Fred talked about data minimization. So, only requesting the data that we require. We've all got accustomed to filling out long forms and asking for all sorts of things, but we need to relook at some of these things. Purpose limitations, so only using the data for the purpose for which it was obtained. And I think the other thing that is quite interesting with pension schemes is data retention. How long is long enough? Because pension schemes are around for a very long time, and often members come back to pension schemes years after their benefits have been paid, but making sure all this has been captured in the appropriate policies. Both Rose and Fred have talked about the lawful basis and ensuring that for each piece of data that you process, there is a lawful basis, because processing of data outside these bases is an offense. So I think from a pension scheme perspective, what I want to reiterate that trustees should consult the sponsoring employers, because there's obviously going to be overlap between departments in the organization. These are employees of that organization who are members of the pension scheme, and often they're members of the pension scheme long after they leave their employer as well. But whilst you do consult the employer, remember that this is a separate legal entity. And just like how you file separate returns to the KRA, you have separate auditors. It is important that there's a separate application made to the ODPC. So there's a snapshot there in terms of how a scheme operates and the space in which it operates. You've got the scheme and trustees. There's a relationship between the scheme and the employer, because the employer is the one who set it up. And trustees sometimes are member nominated, a combination of member nominated trustees and employer nominated trustees. And then duties are delegated to your service providers. So your administrators, custodians, fund managers, actuaries, lawyers, property managers as well, making them data processors. Members and beneficiaries would be considered data subjects. And then we've got the regulators. So the RBA, KRA, ODPC. I would now like to hand over to Amit, who will take over this presentation.
Thank you, Shruti. Good morning, everyone. My name is Amit Gadia. As I've been given the introduction by Shruti, I don't need to introduce myself. I will just share my screen. I only have one slide to share, so I'll not take too much of your time. Rose, Shruti, Fred, they've amply talked about the law. The law is very clear how we need to comply, but the question is, how do you comply? What are the practicals? So I'm going to quickly run through the practical and the implementation part for the pensions industry. Now, this is only for guidance purposes, and we are not going to be, you will need to seek individual advice. So to start, this is where we are. The starting point is the members of the beneficiaries. So this is the individual, the data subjects, as we call them. This is your starting journey. Once first of all, you need to think about the two main areas which you need to comply with. So internal and external, you can see the arrow here. And then you need to think about the regulatory bodies as well. I'll come to that shortly. So once your journey starts with the member, it goes to an employer. From the employer, you can see the flow of data. How does the data flow? So the data flows from the controller to the trustee or to the scheme, right? Now, this will, as I said, will depend on your individual circumstances. So as has been explained by the earlier speakers, you can either be a controller or a processor. You must determine that. Controller or a processor is a term which you will come across throughout the life of your business and for a very long time, if not forever. So you then need to decide, then this employer either goes straight to the scheme or he goes to the trustee, right? Once he goes to the scheme, then the scheme also needs to decide whether he's going to be a controller or a processor, or the employer might go directly from the employer to the service provider. The service provider is normally a processor. As you can see, they have got no other duty apart from processing the data. Processing is a technical term in data protection terms. I don't want to go into it, but it's simply to state that you must, a processor must have written instructions from the controller, right? And then they must have data, the data, what do you call it? Data processing agreement. But then service providers can also be controllers for their own organizations. For example, if they are processing data of their employees, right, they'll be controller in that aspect, right? As I said, it is a very technical relationship. So you need to decide whether you're a controller or processor. From there, the service processor goes to the administrator, then the administrator, for example, Zamara, then it goes to the fund manager or to the custodian. Likely, the fund manager or the custodian is a sub-processor. Okay, then if the employer goes straight to the trustee, they are a controller or the processor. The scheme also then goes to the trustee. Then the trustee needs to decide, are you a controller or a processor? And then from the trustee, the arrow then goes to the service processor, who is who is a processor. Now, as you can see, there are many elements involved in this relationship, right? So it is very important to decide from day one, because if you in any event get this wrong, then the whole chain of effect, and it will have a domino effect. You are not likely to get it correct. And this will also demonstrate one of the key principles globally of data protection, which is accountability and transparency. This is where it all starts. Once you have got this right, then you need to think about the regulatory bits. So as earlier said by Fred, Rose, Shruti, so regulatory requirements, do you need to register? The guidelines are very clear. Do you need to have data protection impact assessment? Demonstration of compliance. How are you demonstrating, right? Globally, accountability, the demonstrate is all about demonstrating continuous. It is not a one-day process or a checkbox exercise that you go and you get a report, a fancy report in hundreds of pages, and then you file it in the locker. No, it is continuous demonstration of compliance. Data retention, right? There is a specific provision in the Data Protection Act which requires you to have specific data retention periods. This is somewhat it is a bit of debatable in pensions industry that how long do you retain the data for? So it can go into for decades, right? But again, you need to justify that. And finally, audit readiness in terms of regulatory purposes. So for example, tomorrow, if there is any form of data breach, if you get an audit from the ODPC's office, you must be ready to demonstrate this. Then on the other spectrum, we have the internal and external compliances. So record of processing activities. Now, record of processing activities is not stated explicitly under Data Protection Act. It is under the GDPR. By the way, today is 18th of May. It just reminds me, it's GDPR's 5th birthday. GDPR came into force. Our Kenya law is modeled a lot on the GDPR. I would not say mainly because it's borrowed from other jurisdictions as well. But then it is quite a bit modeled on the GDPR, and GDPR is 5 days. So record of processing activity, though it is not required, but then my question is, how are you going to demonstrate accountability to the ODPC's office? How is this data coming in if you do not know what data is coming in, how the data is going out, and then if you have the data in place, you will be able to demonstrate compliance. Then we come to policies. There are certain mandatory policies you must have as per the Data Protection Act, which is the data protection policy. Though the privacy policy, privacy notice is not explicitly mentioned, but the Data Protection Act specifically states that you must fairly and transparently have the process individual's data. So privacy policy. And then there is a whole host of other policies, data retention policies, CCTV policies, vendor management policies, a whole host of policies which you may need to have. Agreements, I don't need to go into this. I think the speakers before me have specifically stated that. Agreements in terms of you need to have data processing agreements, that is by law, international data transfer agreements, data sharing agreements or data processing agreements, data controller data process agreements, okay? Technical and organizational measures. This is a very broad term, right? Sometimes it causes confusion, but it simply means you must secure data, either which you have it in your organizations. So when we talk, when I talk as a practitioner about securing data in technical and organizational terms, a lot of organizations come back to me that this is a very difficult process. We need to have a cybersecurity expert. I say, no, you need to start with some low-hanging fruits. It's as simple as that. Like if you have, especially with the pensions industry, you have paper on your desk, right? Why is it not under lock and key? Why do you not have password change policies, right? Why do you not train your employees? So these are some low-hanging fruits. Firewalls, encryptions, yes, those are definitely, they are very, very important. But to start with, you need to avoid data breaches, especially you must have seen several data breaches recently. So some of those breaches which I've been involved in, not breaching them, not hacking them, but advising them, is some of them did not even have a password change policy, right? Or the documents are not in a safe cabinet, right? Those are some of the low-hanging fruits. Data protection officer, Fred, I think I said sufficiently on this. I don't need to go into this. However, data protection officer, the only thing I wish to add to what the previous speaker has said, there must not be conflict of interest. So you cannot have your CEO as your data protection officer, or your marketing guy, or your you may be able to have the legal department, but again, you have to avoid conflict of interest. Okay. Data subject rights and access procedures. Again, if a data protection, if an individual comes to you for access, you must give them within a certain time frame, right? It ranges from what the regulations say 7 days, well, reasonable time, to 7 days and maybe 14 days. You need to consult the regulations. So you need to have, and then consent mechanisms. Finally, most importantly, how do you implement? It is all well and good to have the policies, agreements in place. So you need to have an implementation roadmap, a plan in place. Okay, this is one of the hardest bits, right? Implementation, because you will need to demonstrate compliance to your data subject, the individual, your external, internal beneficiaries, stakeholders, and to the ODPC. So you need to have a roadmap. So that's the final part I wish to cover now is how, I mean, the previous speakers already spoke about reputation, trust. So let's talk a bit about reputation and trust. Data protection is about transparency, accountability, customer trust, and reputation. A Cisco benchmark, which was published last October 2022, with an anonymous survey across 26 geographies of more than 3,100 security professionals familiar with the data privacy. 95% of those 3,100 said 95% said privacy is a business imperative. There is no choice. 94% said the customers will not buy from them unless the data is properly protected. And 95% said privacy is an integral culture. So you can imagine where we are heading as Kenya. We need to be part of this. You can read the full report here. There is a link here. More importantly, all of us, well, the organizations are in the business of bringing value to the shareholders, right? End of the day, how much money are we going to make out of this, right? If we are going to serve, that is good. But how much are we going to spend and what returns is it going to give us? If you go into this report, the privacy spending has been increasing. It's been doubling, right? Almost every year. You can see that. And this year it is likely to double. So privacy spending in 2022 was $2.7 million, right? On average. Okay, I'm talking, and this takes, you know, the big techs. But then what are the benefits, right? So you can see over here, the privacy benefits is almost, the return on investment is 1.8 times in dollar terms, right? So it is very important that you might think this is a costly exercise, this is time consuming, but then this is, once it enhances your trust and reputation, as I clearly said, your customer will not buy from you unless you are properly protected. What's going to happen is that it will affect your bottom line, right? Yeah, and that's all I wish to state. Thank you very much for having me on this webinar.
Thank you very much, Amit. Thank you once again to all the speakers. It's been an enlightening session. I feel quite privileged to be amongst lawyers as well. And we can now go into Q&A. There's already been some questions in the box. If there's any more, please go ahead and ask. I will read out some and we can answer them. Priscilla is asking that for editing and amending the registration. So at the point of registration, you know, they forgot to, that their organization transfers information to their headquarters in US. And how is it possible to amend these details? I think Rose, I don't know if you would like to take that one.
Sure. In terms of amendments or changes to particulars, you can always submit an email to us at registration@odpc.go.ke and just advise that those particulars have been changed, especially if you've already gone through the process of an application and a certificate has been issued.
Thank you. Another question, and is that service providers of pension schemes, so you've got your fund managers, custodians, administrators, auditors, they all have contracts with the controller. Do they need to have contracts with each other to share data, so data sharing agreements? Fred or Rose, if you'd like to take that one.
I can take that one as well. With respect to sharing of data with each other, if they don't have contracts with each other, then yes, they would have to enter into a data sharing agreement. But also the agreements that are already in existence needs, if there's a processor type agreement, needs to be amended so that it can comply with the regulations. There's specific provisions and minimum standards or minimum provisions that need to be put into place for data processing agreements. So they need to be reflected in any processor controller agreements that are already in existence. So perhaps doing a contractual audit or contract audit to find out whether the contracts actually adhere to the requirements of the Data Protection Act. But yes, sharing with each other would require a data sharing agreement.
Okay, so I guess it's making sure that we've reviewed all our contracts. There's another question here from David Nyakundi that says, you know, we're differentiating between schemes and trustees for purposes of whether you're a controller or processor. Are they different entities on the DPA? And I guess who is the controller? Is it the trustees or is it the scheme? Again, Fred or Rose or Amit.
Yeah, happy to come into that. Thank you for the question. The important part you need to understand is who is determining the means and purposes of processing that data, right? Our data protection act is very clear that a data controller is an individual or a body who individually or jointly determines the means and purpose of processing data. So let's take a very simple example at the moment. If you are an employer, you have employees, you take the employee's data, and you then feed it in your systems, and then you process their data for purposes of their employment. That makes your controller because you're determining the means and purposes. If you then share it with an external organization, for example, a payroll company, their remit is simply to process payroll. They cannot do anything. So, for example, they cannot start marketing their accounting services to them, right? Unless they have consent. So that makes them a processor. Okay. So the starting point is that who is doing with what data that needs to be then condensed into a data processing or data sharing or data controller processor agreement. And then you need to come up with the data sets as an appendix in that agreement and then decide who is going to be what. There is going to be more technical, they can be joint controllers, which is at the moment outside the ambit of this webinar. So if you are controllers, then you also, both of your controllers, you need to decide what data are you both of you going to be sharing, and then reduce that into an agreement. That is very important. Okay. So as I say, it is not simply, there is sometimes a misconception that one person says, I'm a controller, the other person says, I'm a processor. No, it is not as simple as that. The controller-processor relationship is dictated by the law, not by choosing of an entity. Yeah? I hope that answers your question.
Thanks, Amit. There's another question here that says, it's argued lately that data subjects include organizations, legal persons, and not only natural persons. Kindly expound on this.
Yeah, happy to come on that as well. So our data protection is clear that if it's any data which identifies a person or is identifiable, right? And then if you look at the definition of sensitive personal data, that is clearly shows what sensitive personal data is applicable. So it applies mainly to natural persons. Okay. There are authorities globally. There is a case going on in US that they are trying to argue that it might even be applicable to legal persons. But should you then choose to make it applicable to legal persons, what you are doing is that you are then opening a Pandora's box, right? Which I would suggest at the moment is not required. So it's natural persons.
Thanks, Amit. Sorry, the requirements to comply as a data controller can be quite financially heavy. So with the objectives of a pension scheme, where essentially they're not, it's not for profit, how can you justify this extra cost to members? I don't know, Fred, if you would like to jump in on that.
Yeah, thank you. Yes, it's the aspect of those policies and which you are required to put in place, and also maybe the data protection officers, they might be required to be paid if the scheme brings him or her in. I think there is not much, and in some of the cases, it's a one-off cost, like now coming with those policies. So I think I'm sure members will understand, because they need also to be educated. First of all, as I said, education is key. Trying to explain to them that this is the law which has come in place and it is for your benefit. It needs to come out clear that whatever the data protection is trying to enforce is to the benefit of these members. And once they understand it from that perspective, that it is benefiting them, and maybe some of the costs will be for those policies, which will be one-off, and maybe the data protection officer can be shared among maybe a number of schemes to reduce the costs. And I think if that is implemented, I think it can be well explained to the members. Thank you.
Thank you, Fred. Another one, I think, for you, Fred. With increased fraud, what safeguards are in place to protect trustees or service providers if data is obtained fraudulently?
I can take that. If data is obtained fraudulently, I think one of the things that probably needs to be shared to our office, if it does end up being a complaint or it's a breach notification, is I guess what has been taken into account in terms of safeguards by the pension scheme and the trustees as well, and also advise that there was nothing that could be done in terms of everything has been, or everything is in order, and perhaps some malicious person decides to take that information. As mentioned, as part of our breach notification requirements, we don't tend to penalize on that basis. However, if there is a complaint that has been managed and we can pinpoint the person who's actually responsible, we will hold that person responsible. But I do know, and I'll leave this to Fred to answer, I do know that as part of the trustee pension scheme relationship, there's also safeguards for the trustee with respect to just their liabilities for certain things. So perhaps maybe Fred can also deal with that from a liability aspect of the foundational documents, I guess, to create or to appoint trustees.
I think, Rose, you have really covered it well from the perspective of the data protection. That safeguards can also apply to a pension scheme as well.
Thank you. So it's having the processes, policies all in place as well. The trustees are data controllers, but some of the information is actually held by the sponsor confidentially, like example, salary information. How is this information maintained confidentially without infringing on the rights of the data controller? So I guess it's, this is where maybe there's a bit of overlap and a bit of confusion in that the employers have this information and now the trustees being custodians of the scheme, and where the liability, I guess, lies. I'm not sure who'd like to take that one.
Yeah, happy to take that. Thank you for the question. One thing you need to understand is you need to start, even if you're a custodian, where are your instructions stemming from, right? Are they stemming from the administrator? Are they stemming from the service provider? Are they stemming from the scheme, right? Once you break it down in a very bite-sized chunks, then you'll be able to see exactly who is responsible for what, okay? It is not advisable to, or not recommended to just generalize whether it's employment or service providers. As I said earlier, the legal relationship is dictated by the law. It is not by choosing of any particular entity. So the starting point for any organization, make a map, see exactly how the data is flowing, and then reduce that into your legal relationships.
Cool. Thanks, Amit. So data mapping and understanding the map of how everyone relates is a crucial start to the exercise. Benedict is asking, do we have procedures for accessing data by the data subjects, and what are the timelines stipulated?
Okay, so the timelines which are stipulated, as I said, the regulations stipulate anything between reasonable time to 30 days, right? Well, to 14 days, some are 30 days, but you need to refer to the data protection regulations, which are very specific onto the timelines. One thing also I need to state is that there are exceptions to giving data subject access requests. And these are, for example, if it is against the law, if it is going to be a infringement on anybody else's privacy, if there is a court order, if there is some form of enforcement. So, tomorrow if you get a data subject access request, don't think that immediately you need to give all information, okay? And the second thing I need to state is that it is also important to identify the data subject. So for example, if Amit Gadia tomorrow asks that, can I have my data, right? You can't say, okay, fine, this is your right. I'll give it to you. Then supposing if I'm an imposter, if somebody else is posing as Amit Gadia, right? You need to identify them. So these are two key elements. What are the exceptions applicable? What is the time frame? And the third key element is identify the person.
Thanks, Amit. I guess, yeah, this still someone wants clarity on, do we register the trustee or the scheme itself as the data controller or data processor? I don't know, Rose, if you'd like to give some feedback on
that. I think before Rose, I can explain, and I combine it with a question by Mr. Nyakundi. He's also saying a scheme in Kenya, in most cases, is not a legal person. So yes, there could be those schemes which are not registered as legal person, whereby they have not been registered under the Trustee Perpetual Succession Act to be legal entities on their own. So some of those schemes, if there's they need to register to be legal persons, if they can. And if you find a scheme, now to combine it with this question, if you find a scheme as registered under the Trustee Perpetual Succession Act, then it qualifies as a legal person, and now it can register itself in its own name. If you find a scheme which has not registered, you find in most cases, property of the scheme is registered in the names of the trustees, then the trustees are the people now to register itself. But I would highly advise that it's now high time that most schemes register under the Trustee Perpetual Succession Act so that they become legal entities. That one, it is easier now to execute most of the things, including even registration of properties of the scheme. Thank you. Thank you, Shruti.
Thanks, Fred. So sorry, just to clarify, in terms of registering with the ODPC as well, is it the trustees that are registering, or is it the scheme?
If the scheme is registered under the Trustee Perpetual Succession Act, then that scheme is a legal person. So it can register now. It can qualify it as a data processor, or in most cases, a data controller. It can register. But there could be schemes which are not, there are some, because some schemes are registered, it's not a requirement. Most trustees do that for purposes of, so that it is easier, because the property of the scheme is registered in the names of, in the name of the scheme, so that even if trustees changes, there's no problem because the property is registered in the names of the scheme. There are cases whereby schemes a scheme is not registered as a legal person. And in such cases, most of the property or all the property of the scheme is registered in the individual names of trustees. So in such a case now, it is trustees to be registered. But I could highly advise that it is high time that most schemes now register, or all schemes now should register under Trustee Perpetual Succession Act, whereby they become now legal persons. And they will be capable of doing so many things, not only to register even with the Office of the Data Protection, but even the property will now be registered in the name of the scheme, so that even as trustees change from one trustee to another, there is no need to make those changes in the lands office. It is easier that way.
Thanks, Fred. Rose, any thoughts on that? Anything you'd like to add?
No, I think Fred has adequately captured. I have the same sentiments. I think most times it's very difficult to appreciate which legal entity does need to register. I would say that entities do need to get into the practice of registering, especially trustees and trusts under the appropriate laws, so as to enable them to have a legal entity. But I mean, it is arguable, given that the decisions, really the decision-making power of how the pension scheme will be run is made by the trustees. And so it would be a requirement for the trustees as a whole, not individually, but as a whole, if they can, to register, but also the pension scheme specifically to register as well. But completely in agreement with what Fred's has mentioned and the direction that he's given as well, because it gives clarity to the office if an entity has illegal backing and can come to us as an individual standing rather than, you know, different parties or different natural persons representing the pension.
Thanks. Thank you both. I'm going to take a final question before we wrap up. I think someone is asking, does a person in your employer's organization have the right to contact your medical insurance provider? Presumably the medical insurance is an employee benefit, to access your hospital medical records or information without your consent or notification as an employee?
I'll take that, Shruti. This question has a lot of limbs, right? First of all, can an employee share the details of the employee? I believe this was the first question. Can it be shared to an employer by a medical practitioner or medical insurance provider? Okay. So first of all, if they have a lawful basis and if there is any purpose. So first of all, you need to identify what is the lawful basis, what is the purpose. And then if it is, say, for example, a medical insurance provider, is it a controller or a processor? Is there an agreement in place? And have they informed by a privacy notice or a privacy policy that they need to share the data? And this has to be communicated both by controllers and processors to the individual, okay? Without infringing the rights of an employee of confidentiality, first of all, what are those rights of confidentiality? Is it necessary? Because under our Data Protection Act, there is something called vital interest. So if you are a lawful basis of vital interest, my apologies. So if you are, for example, you're an employee, you faint at your place of employment, right? I'll give you a very simple example. Then even if you do not have consent, but then you are saving somebody's life, right? Then you can rely on vital interest, right? So as I said, this is actually an examination question, which at the moment, I can give you some pointers. And is sensitive data shared without an employee's consent? One thing as I said, you need to understand the sensitive data is a subset of personal data. So whether or not you need an employee's consent, it is debatable. It depends on the context of the employment. So for example, if it is a nurse or a doctor working in a hospital, contractually, you are required to share their data or in a construction industry or in an industry which involves explosion and where there is high chances of getting injured, you need to share the sensitive data, say health data, for example, okay? But in a place, say if it's a marketing company and you are sharing an employee's health data biometrics, right? Is that proportional? Is that in line with the principles of data minimization? That is questionable. And that is where you need to do your data map. And then for each category of personal data, you must come up with a purpose and a lawful basis, right? I mean, I've really explained it very quickly, but I mean, as I said, this is an examination question. So yeah.
Thank you, Amit. With that, I'm now going to conclude. I'd like to thank our speakers, for giving us all these words of wisdom. I think it's been a very insightful session and given us lots of food for thought. I'd like to thank the audience for being so engaging and provoking and prodding the debate. I think us having this debate is going to help, build on the good work done by RBA in terms of building the retirement benefits arena in Kenya, and the ODPC, for encouraging us to treat this data with the due care and respect it deserves, establishing this culture of privacy and trust, which is essential for the growth of our economy and the growth of the pension scheme space. So with that, I would like to now conclude. I've put in our email address if there's any more questions. And yes, thank you once again. I'm sure we will all be in touch soon. Take care. Bye, everyone.
Goodbye.